The article that Steve and I wrote proposes a limited antitrust exemption for certain non-unionized employees and independent contractors to create joint negotiation entities for the purpose of collectively bargaining with employers in order to achieve higher wage rates. These joint negotiation entities, which we call J&Es, would be limited to negotiating only with employer firms that are likely to have monopsony bargaining power. This could be either classical monopsony power or a dominant degree of bargaining power. Such monopsony power suppresses both wage rates and output in the relevant labor market. The proposal is based on economic analysis that indicates that moderate worker bargaining power can be beneficial to downstream consumers as well as workers when the employer has monopsony power. The result is not just increased wages and employment, but also increased downstream output and lower downstream prices. For purposes of the antitrust laws, each J&E would be treated as a single entity that is owned by its worker members. They would be generally subject to the same antitrust treatment as other single entities. The J&Es would be easier to form than unions, but J&Es would have fewer rights and less power than unions. Thus, by contrast to some unions, J&Es would be unlikely to become monopoly sellers of labor or vehicles for industry-wide producer cartels. While the proposed antitrust exemption and related worker protections would be limited, they nonetheless could lead to benefits for both workers and downstream consumers whose interests would not conflict. We recognize that the underlying analysis might be relevant for small firms that buy or sell from counterparty firms that have dominant bargaining power. Steve analyzes this possible extension in a subsequent article.